Welcome to Talk Law Radio with attorney Todd Marquardt of the Marquardt Law Firm at marquardtlawfirm.com.
Welcome back to Talk Law Radio. I'm Todd Marquardt here with Stetson, attorney for Marquardt Law Firm, talking about real estate title and probate issues. This is our fourth segment. It's the legacy segment.
And now, it's time for the Talk Law Radio Legacy Spotlight. What's your legacy? Sponsored by Marquardt Law Firm.
Stetson, you know attorneys at Marquardt Law Firm focus on business and estate law, including last wills, living trusts, and tax-protected inheritance plans. It's all about legacy.
Correct.
What insights have you learned about legacy from working with clients doing probate and estate planning?
Well, on the good and the bad, the story's the same. There's just one clear difference. Really, if you have wishes and you've expressed those wishes, whether verbally, whatever it may have been, make sure that you put them down on paper, preferably in an estate plan drafted by us. That way we can ensure everything is exactly how it should be. But yeah, if you want to leave a legacy, you've got to do a little bit of legwork prior to leaving this earth. To leave a legacy, you need to do some legwork.
Amen. In our first segment, Joseph Warren with Financial Planning HQ mentioned that legacy and financial wealth can be lost by the third generation. Some people refer to the old American proverb, shirt sleeves to shirt sleeves in 3 generations. And so if we want to make sure that that doesn't happen, that somebody's legacy isn't lost in 3 generations, I think that you have to be more intentional about what kind of estate planning you do. You should definitely have a last will and testament. Everybody over the age of 18 should have one, even if they think they own nothing, because you could be worth a lot of money if you get hit by an 18-wheeler or physician makes a medical mistake, and one of those advertising on TV could get you millions or jillions of dollars, and then you need an executor to file that lawsuit. Another thing is that you can leave an inheritance to your loved ones where they put it under the mattress, or you can leave it to them where it's protected, like in a safe. And the difference is if I just leave an inheritance to you outright, that means no restrictions. That means you can spend it any way you want. And that also means that it's subject to claims from creditors, judgments, liens, divorcing spouses, business setbacks, economic downturns, and frivolous lawsuits. Or I can leave it to you in a testamentary trust that has a spendthrift clause on it that says that nobody can take your inheritance, that even if you go bankrupt, even if your wife takes everything that you have, they can't take your inheritance. How powerful is that?
Very.
Yeah. So do you have experience with clients who wrestle with that option of whether to leave it outright or in trust?
A lot, yes. Every family is different, and every person or child, or whatever it may be, adult child is different. So we often have that conversation a lot of times for a pretty long period of time, because, it's an important decision. Do you want some strings attached? Do you trust them with what you're fixing to give them?
Well, even if you trust them, none of us has a crystal ball.
Sure.
We don't know if these thieves are going to come out of the woodwork. There's criminals out there that will send you things in the mail that say that you owe money when you really don't.
Yeah.
And so we have to guard against that. Another thing that I was thinking about was divorce. Some parents that I talk to, they love their children dearly. They say, my children have been married for decades. They're never going to get divorced. They are good with their money. They don't have creditors. They're perfect angels. They're never going to fight after I die. And so we just want to do something simple. And I say, you are truly blessed to have a perfect family and perfect children. I wish that I had that.
Yeah, same.
We see so many problems. People come in and God bless them, they're in distress because of family conflict or because of a divorce or a second marriage, or their parents diverted their inheritance over to a replacement spouse unknowingly. That I worry about everybody. I had some friends at church that years ago, nobody will even know who I'm talking about, so don't think it's you. But they got divorced, and everybody was wondering, how did this happen? We didn't know that they were even having problems. It was just like all of a sudden, oh, they're divorced. And so what I've learned is that none of us knows the future. So we have to do some preventative planning. Mm-hmm. We have to try and anticipate the unexpected and plan for the unknown. That was my tagline years ago.
Yeah.
So what do you suggest to clients in addition to just having a will? What do you encourage people to look out for?
Well, if it's just a will-based plan that they're getting, well, my first question would be, how are your bank accounts set up? Are there any POD beneficiaries named? Because if there's not, please update that and put that on there. Same thing, with their residence. I would say for most average people anyway, the most valuable thing that they have is usually their home. So it's important to handle that correctly, and there's many ways to avoid probate for that particular asset. So really want to focus on that. Yeah.
Well, let's go through a hypothetical scenario about somebody who dies and really wanted his stepchildren to receive his house and his inheritance.
Yeah.
What could go wrong if you die without a will and you want your stepchildren to receive an inheritance?
Well, first off, if you die without a will, you're going to need to go through, or one of your family members is going to need to go through an intestate probate. And within that, there's going to have to be a determination of heirship. So the individual here in this hypo didn't write his own will, so he didn't get to determine how his assets were distributed. The state of Texas decided for him.
Right, it's in the statutes.
Yeah. So depending upon who he was survived by, whether it be a mother, a father, or siblings, that's who it's going to go to. Assuming he's not married or if he's a widower or whatever it may be.
There's so many factors.
Yeah. You have no control at that point. Zero.
And so what would be better if you wanted to leave an inheritance to your stepchildren?
Well, you need to put it down in writing for sure, because stepchildren are not in heir at law if they're not adopted or anything like that. So you would need to put it in writing if you want to provide for them.
In a last will or living trust or something?
Yes.
Okay. So let's assume that he wants not only to leave them an inheritance, but he wants to make it easy for them.
Yeah.
What would he do with that?
Ideally, he would create a revocable living trust and make sure that trust is fully funded prior to his passing. That's best case scenario. And I think his stepchildren, assuming they were the ultimate beneficiaries of that trust, when they would come to our office, hypothetically, they would be very pleased to find out that they don't need to go through this process called probate. Everything has been taken care of. And, their heartache of losing their stepfather doesn't have to turn into headache of having to go through probate. It's all buttoned up.
Right. And so if people want to make sure that their wishes are followed, that their wishes are legally enforceable. They should probably see an estate planning attorney to make sure that the words that they write down on paper are legally effective. In the previous segment, I told you about a Frankenstein power of attorney deed. I also had a different client who had a Frankenstein revocable trust will.
Okay.
And so what happened is it said revocable living trust at the top, but then it appointed an executor, and there were no assets titled in the name of this revocable trust. And so I filed it as a will for probate, and the staff attorney said, yeah, this is a will, even though it says revocable living trust. Because it appointed an executor to serve without bond. It was just, I really cherish those Frankenstein documents.
Was it self-proven?
I don't remember that. I'll try and find a copy so I can show it to you. I'd really like to have like a collection of Frankenstein documents that we can use to train our staff. But if this sounds like something that your parents are going through or something that you're going through, if you think that you've inherited property, don't wait years or decades to try and get it cleared up. You need to talk to an attorney right away, because people get scattered, people die, and those family relationships, those relatives, you're going to need everybody's cooperation to get things cleared up. I've had some people that said, I should have inherited this property. My granddaddy died 40 years ago, and that's just not...
It's not how it works.
Well, it's not a good starting point. I mean, if you have enough money, I guess it's possible to clear any title.
Yeah.
Thank you for being on the show.
Very welcome. Thank you for having me.
Did you have fun?
I did. It was a blast. Yeah.
Awesome.
Thank you.
Well, if you need an attorney, call Marquardt Law Firm at 210-530-4278. We'll talk to you later.
This has been Talk Law Radio with attorney Todd Marquardt, brought to you by the Marquardt Law Firm. You can learn more at marquardtlawfirm.com. And be sure to listen to the full Talk Law Radio show Saturday mornings at 11 on 9:30 a.m. The Answer.
Most families don't realize they have hidden legal blind spots until it's too late. Wills, trusts, Medicaid planning, even protecting a business. These are the kinds of issues attorney Todd Marquardt helps uncover before they become problems. Todd is the host of Talk Law Radio, where each week he guides listeners through the legal challenges families, veterans, and business owners face, while showing them the practical steps to protect what matters most. Catch Talk Law Radio, Saturdays at 11 a.m. on 9:30 a.m. The Answer, 6:30 a.m. The Word, and now in Houston on AM 1070 and 103.3 FM The Answer, or anytime on YouTube. Planning isn't just about documents. It's about peace of mind, security for loved ones, and building a legacy that lasts. Don't wait for a crisis. Do it before you die.